una silla porque vamos a comentar la.
Sí, me dijo que sí, porque me dijo, no, no se puede, bueno, creo que sí, porque, bueno, tranquilo.
Es que lo que no sabía es si este salón se podía, pero
Sí se puede. Sí se puede. Entonces, lo que tenemos que hacer.
como ustedes quieran, mira, vamos a hacer cinco.
Pues,
Pues que quitas tu puño para más espacio. Puedo sentar acá si quieren. Y vamos, ¿ustedes quieren?
creo que sería bueno, yo me pongo en uno de los carros, porque seríamos de escribir hacia el centro.
Sí, y si quieres dejamos a Meg aquí
Yo,
y ustedes dos en net, donde quieran.
te digo que
Y aquí, pues,
porque hace un frío de que
no, todo es la tradición.
de cambiar eso.
No,
Cuando va a llegar, pero no.
porque Justicia TV me pedía algún video cortito para subirlo a las noticias. Un cortito. Tal vez donde esté Margaret, tal vez. Creo que seguramente será la voz más. Bueno, debería. Ya no voy a decir nada. Ujú. Va a ser primero Lawrence, luego.
Pero ya es que Laura,
Ah,
sí que
ujú,
soy yo,
ujú.
pero Laura.
De que ya los estamos hablando.
Yeah, I got it. Yeah. So I have to. Yeah.
Oh, okay, I actually I can wait in part. Yeah. Or you think of did it work? Okay.
Yeah, yeah, I'll pull it up.
Okay, thanks. Thank you.
Y luego,
Úrsula, ¿no?
luego la relatora, después
sí,
de la
la relatora.
relatora, luego ustedes, ¿en qué orden van a hablar?
Primero yo.
Ok. Y luego Úrsula, pero ya que
Ah,
empezamos por el drama de México, que nos cuenten en la región y qué ha pasado.
Y entonces lloramos ya todos juntos.
Ya.
Ujú, exacto.
No podía, no hubiera podido hacer. Esto es una que no me tocó, y entonces
Voy a.
Test, test, 1, 2, 3.
¿Puedo pedir si pueden dejar este
Primero.
firmando atrás?
Sí.
es el release para que puedan
Se
dar
usen
la
todo.
grabación, ¿sabes?
Ujú. ¿Y aquí está el nombre del programa?
Sí. Judicial.
Ujú.
Aquí está la antes de que se haga las 11 que para que podamos empezar. Por eso te digo, no, de 11 a 12 y de 12 a 1. Las 11 a las 9. Digo, porque a las 8 nos van a mandar a el nombre del programa que es
Judicial
Ah.
Reform in Mexico.
Ah, ok.
Bueno, eso le puse. Cambio.
Una vez si quieres
Y aquí está.
de los
State of program.
¿Y dónde estuviste?
Yo estoy en México,
Ah,
la licenciatura de Bautismo,
¿en dónde estudiaste en México?
en la escuela de Derecho.
Ah, de la Liga. Muy bien. Y aquí
No
en
estuviste.
Colombia está padrísimo.
Sí, es que fuimos hace ratito.
Ah, qué bueno.
Pero no fuimos a Derecho, fuimos a Antropología.
Que nos dijeron que está en otro edificio, ¿no?
Sí.
No, no a las 11. A las 9.
¿Está por ahí mismo?
Sí,
¿Y de qué generación eres? De la Libre.
2006, 2011.
Es que chiquito.
¿Conoces a Carlos Guerrero? De los
Sí.
niños?
Él es mi amigo, no es de la misma.
Ah, you. Nice to see you. How's it going? Yeah. How you doing? That wasn't terrible. But she wasn't at her table.
The top of the, oh, no, it wasn't fair, because, you know, you were the president of the chief justice. Oh, sorry. Thank you so much. So I don't know what happened. I mean, the story. No, I just, it was like, yeah, the same parts, but it's because, you know, we don't know when they put the record, like, first is report on it. Yes. Yes.
Hello, Ursula. Can you hear me?
Hi, yes, you can hear me too?
I didn't quite hear that. Say that again.
Can you hear me too? No?
I think it's just hard because there's a lot of speaking in the room now, but I do hear your voice coming through.
Okay, great. Yeah, I'm not speaking very loudly, but I could if it's necessary.
Nope. I think we're all set now.
Great.
All right. So I will have the PowerPoint up on the screen, and when it's your time to speak, I'll bring your video up.
Okay. I'm renaming my window. Okay. Okay, I'll be here. Do you want me to turn off the video or? Should I turn off my video?
soon because there was a health issue. But thank you still, Ursula, for joining us remotely. We'll be hearing from you later. And I'm assuming that most of you know about this reform and how the process to come to where we are today. And I mean today because there are things happening today, right now, actually. But just to say that the Van Center for International Justice has been working very closely with judges and judicial associations from 15 countries in Latin America, trying to support and strengthen their work to have a better or stronger judicial independence and integrity. In the case of Mexico, the City Bar and the Fan Center issued a statement a couple of weeks ago explaining what this reform is about, the specific points of concern, and to explain something that's very important, which is the context in which this reform is happening. And we'll recognize that every country has a right to define how they want to arrange their judiciary, how they want to establish their mechanism to appoint judges. But it's important to remember that this reform is happening in a context where the president and the political party of the president, Morena, has been trying to take control of other institutions. So basically playing with the check and balances in Mexico. This reform, as you know, was not directly originally to only the judiciary, but another reform is being discussed to get rid of the constitutional autonomous bodies that were created starting 25 years ago, probably closer to 30, with the idea of having specific bodies that would be in charge of technical matters that we didn't want the president to be in charge of, because we didn't want those topics to be part of a political agenda, but rather of a respect of human rights or technical agenda in whatever the topic was. One of the main examples and one of the very concerning matters is the National Institute for Transparency, which has guaranteed that for many years, civil society organizations, think tanks, and in general society is able to know what's happening with the government, what they're doing. And now the idea is to get rid of that too. So the point of having this reform to the judiciary and the rationale behind the reform is really the discontent of President López Obrador with the judiciary. And this includes the Supreme Court, but also federal judges who have been issuing suspensions and the indictments for cases that are important to him, and the fact that he was not able to control the judiciary in the way he wanted to. So now the solution is get rid of all the judges, federal and state, and have new elected judges in a way that we don't fully understand yet. And it's important to mention that we are not questioning the fact that electing judges is being proposed. That happens in many places. Here in New York, there are no international standards saying that judges can't be elected, but the how and why they're doing this is important. So thank you again very much for being here. And I will pass it to Laurence Patan. Laurence is executive director of the Foundation for Justice, a Mexican organization that has been doing work around justice and justice reform for many, many years. And Laurence is not only a friend of the Van Center, but also an expert in these topics, who have been studying the Mexican judicial system at the federal level and the state level, and is a person, I think, who agrees that we need a reform in Mexico, but not this one.
Exactly.
So welcome, thank you for being here. And it would be great if you could set the ground explaining what is this reform, what are the specific points, and what would the judiciary look like if we can understand even a little bit of what this reform is trying to do?
Sure. Thank you
Thank you.
very much. Thank you very much, Jaime. And first of all, good evening. And it's a pleasure for me to be here tonight. I would like to thank the Event Center and especially Jaime Chavez for the organization of this panel and for the invitation to participate in it. Especially because I have the pleasure to be here with four women I admire deeply. So thanks for the opportunity, Jaime. Today I will speak on behalf of the Foundation for Justice, which I have the pleasure to lead, but also as a member of the coalition La Justicia que queremos, which means the justice we want. So as Jaime mentions, there's a specific context that is very hostile for the judiciary in Mexico right now. I won't go into details because he mentioned already some of these problems. But that being said, as he said, we didn't, agree on that slide. But actually, the Mexican justice system is actually not anything but perfect. And in the coalition, the justice we want, we agree that a reform is needed, but just not that reform. We also agree on some of the arguments that are used to justify the reform, namely that the Mexican judicial system is, difficult to access and that it is costly, that it fosters impunity, and that it is too slow. Thus, we agree that there is an urgent need for to improve the justice system, but we think it is important to make it more efficient, to make it faster, but also it shouldn't, focus only on the judiciary, but also and primarily on the General Attorney's Office, which is very inefficient in Mexico. And the problem is that the proposed reform does not address any of these issues and would actually probably worsen the current situation, as we will see in a minute. But what does the reform propose? I'd like to point out three main aspects. First of all, the reform proposes to remove all the federal and state judges actually in office in the country in a 2-year period and replace them with people who would be elected. And what are our concerns with this proposal? First of all, the 6,500 judges in the country would lose their jobs and be replaced with people who potentially would have no previous experience in the administration of justice. This implies that instead of making the system more efficient, the reform is likely to paralyze courts for a great while, actually, while these people learn how to do the job. And it's important to stress that in implementing such a reform, Mexico would adopt an unprecedented model, since it would be the only country to select all its judges through this mechanism of elections, because no other country, has all these their judges being selected through elections. Another issue is the fact that the reform does not establish mechanism to guarantee the candidates' technical capacity, or that they get their job through meritocratic processes as recommended by international standards. It is important to say that currently federal and state judges are appointed through competitive exams that value candidates' knowledge, capacity, and experience, while federal and state Supreme Court justices are appointed through political processes, usually involving the executive proposing candidates and Congress appointing them. With the reform, the election process would go this way. I'm going to be try to make a summary of how it would work. Each branch of government would appoint an evaluation committee made up of 5 prestigious law experts, but the initiative doesn't specify the criteria for their appointment or the requirements that they should fulfill. The reform then establishes that each committee would generate a broad list of candidates, but it doesn't state the methodology to come up with this list and how these committees would, evaluate the candidates. Then from this broad list,
there would be a draw to establish that the final list of candidates for each branch of government. And the reform says that each branch would have to approve this list, but it doesn't say what would happen if a branch does not approve it and, decides, well, not to present those candidates. And after the list of candidates are approved, they participate, those candidates participate in a 60-day campaign without having access to public or private financing, and voters would elect, their judges from those candidates. So another problem is that the reform would modify and ease the requirements to be a judge or a Supreme Court justice. For instance, instead of having a law degree for at least 10 years, as is specified now, the reform states that people can be candidates that people can be candidates if they obtain their law degree with a minimum grade of 8 out of 10, and if they practice law for at least 5 years. So we had 10 years before, now we have 5 years. The reform also adds a new requirements, such as that candidates should present 5 letters of recommendations from their neighbors, colleagues, or friends. It's not a joke, I'm sorry. I know it's funny, but it's not funny. And, and it removes another requirement, which was that people had to be at least 35 years old. And now there are no age requirements to become a judge. So that's another problem. And another problem that we have, identifies that the judicial reform faces feasibility issues, particularly in regards to the possibility for voters to actually make informed choices, when they vote, because there's an overwhelming number of candidates. For example, in 2025, each voter would need to choose 41 federal judges from more than 300 candidates. And it is impossible for voters actually to know all of those candidates. So that's for the election process. Then another problem that we see is the Judicial Disciplinary Tribunal, which the reform proposes to create. It proposes to create this tribunal independent of the Supreme Court and the administrative body, and it would investigate and sanction judicial personnel in the event of administrative violations, and its members would also be appointed by election. And we see 4 problems with this proposal. First of all, the investigations can be carried out for acts or omissions that are contrary to the law, to the administration of justice, or the principles of objectivity, impartiality, and independence, which means that, those concepts are so broad that basically, it can lead to a kind of witch hunt. Instead of establishing 2 separate bodies for the process and its appeal, as recommended in international standards, the reform proposes that the first instance should be composed of 3 judges, which would also participate in the appeal body. So what kind of, appeal can you have when, the same people are in both, bodies? Another problem is this tribunal would be in charge of investigating, but also resolving the cases. So it also, contravenes international standards, because normally you have to have one instance to investigate and another one to resolve, And finally, the reform does not mention who would have the responsibility to investigate and sanction possible improper acts from the members of this new tribunal. So we don't have anyone, checking what the checkers are doing. Finally, when we thought the judicial reform was already bad enough, a very problematic new aspect was added in the last few days, which is the possibility in trials where organized crime members are involved to actually hide the identity of the judge. This figure of so-called faceless judges has been used in other countries and was actually considered by the Inter-American Commission on Human Rights and the Inter-American Court on Human Rights as a violation of procedural rights, because it is contrary to the principle of publicity that is the basis of the rule of law, and also it violates the guarantee of being judged by an independent and impartial court. So those are some of the concerns we have with the reform, and I will leave it here. Thank you very much.
Thank you. So a few concerns.
A few.
And I think that it becomes very clear that the way this reform is being presented, it's not really considering any kind of international standard, but really trying to have a judiciary that's going to be useful to the interests of the party. And that, I think that explains the way that these lists are going to function and the way that they're expecting for people to know there are 300 candidates, knowing who the president proposed, and then vote for the ones you want.
If I
Yeah.
may say, because actually they also showed an example of how how do you say that, la boleta? Oh, the ballot, thank you so much. The ballot would look like, and actually, yes, the candidates would be, indicated if the executive proposes them, if the judiciary proposes them, or if the legislative body proposes them. So it would be actually a way to, make people know who they are supposed to be voting for. Excuse me, but that was an important point. Sorry.
Yeah, no, thank you so much.
I thought about that.
Okay, stop now. So it's my honor to introduce Special Rapporteur Professor Margaret Sadway, the UN Special Rapporteur for the Independence of Judges and Lawyers. Thank you very much for being here. You analyzed this reform or the original proposal, and you sent a letter to the Mexican government stating your concerns for some of the specific points that are clearly in violation of the international standards, standards that have been there for a while now, and that we would expect the Mexican government to follow. But it would be great if you can tell us a little bit more about your letter, your concerns, what you think of these latest adjustments they did to the bill, and if well, you can tell us what can we expect from if this reform is passed in the next few days.
Thank you so much. And I want to thank you, Jaime, for organizing this, and then, of course, for the very, as Laurent said, very powerful and brilliant women who are up here. I'm not counting myself among them. So just briefly, I'm going to just say what a special rapporteur is. I recently had dinner with a very eminent judge who turned to me and said, "What? What is this thing?" So just briefly, special rapporteurs are appointed by the Human Rights Council of the UN. We serve independently. We're volunteers, actually, and therefore we're not beholden to any government. We are not put forward by our government. So I don't represent the UN, and I also definitely don't represent the US government, despite being a citizen. So I'm going to just address a few of the key aspects. I think that you'll hear much more in-depth commentary from the others, but my job really is to simply look at law and how it does or does not comport with international standards. And so just a few brief comments, and unfortunately, well, maybe fortunately, because when we repeat things, people remember, but some of them will be already things that have been highlighted. So I think the first thing to say is that it is, in fact, a human right to have access to a judiciary that is impartial and independent. And that's important to remember because otherwise we can get very lost in the technicalities. But the reason is access to an independent and impartial judiciary ensures that we have access to justice and that we can have access to a fair trial. And both of those rights have been elaborated and interpreted to require independence and impartiality. And independence and impartiality then have been translated into a series of norms at the international level that do go into some of the more technical aspects, but they're coming directly from human rights law. And I think it's really important that we remember that. And so the concerns really here are both the specific technical ones and then also the context. My mandate also has been concerned about particular attacks and statements and actually singling out and denigration of individual judges in Mexico by the executive. And it's something that, of course, happens in many countries, that the executive might critique a judge. It's appropriate for them to critique a judge in a decision. But we're talking about crossing that line, individualizing the critique, and actually denigrating and putting people into a spotlight. And in fact, using language like person is an enemy of the people, or they're a traitor, they're a terrorist lover. These are the kinds of things that have been said about judges in Mexico. And I mention that because it created really, I think, it prepared the populace to hear messages about the judiciary being corrupt, not caring about the people, and sort of preparing them to see this quote unquote reform in a very specific light. So I just wanted to mention that particularly. So a couple of things. First, about the proposed reform to elect federal judges. So we've already talked about kind of the political piece, so I won't go into that. But specifically, international standards underscore that, yes, there's no explicit prohibition of election, and there's also no requirement for how judges are selected. But the system has to uphold really the two principles of independence and impartiality. And to achieve this and protect judges from political influence in decision-making, states have to ensure that appointment procedures meet certain minimum requirements. And those are: selection procedures have to ensure that judges are selected based on essentially three things that I think make sense to everyone when you hear them: training and qualifications, integrity, so integrity, honor, the transparency of personality that we look for when we talk about a judicial temperament, and ability. And so those three things are really the touchstones for what makes someone appropriate as a judicial candidate. Whatever method of selection is chosen has to include safeguards against judicial appointments for improper motives. So that would include political motives, of course. And in general, international standards suggest that selection processes, as much as possible, should be carried out by independent authorities. And they should involve civil society and allow and ensure that civil society can be engaged, but also ensuring that selection is very much merit-based. So my mandate has specifically raised concerns about the election of judges, and particularly in two specific states, saying that it's, quote, sometimes seen as providing greater democratic legitimacy, but may lead to the politicization of judicial appointments, with political considerations prevailing over objective criteria set out in international standards. And this mandate's concerns have been in a few different lights on election. First, election allows for political considerations to prevail over the objective merits, and those concerns are heightened in contexts where there is already a mistrust of the judiciary. Further, what we see here is the lack of a transparent, independent, and accessible mechanism for verifying candidates' compliance with the requirements required under international law and international standards, and shifts the verification to this from the Federal Judiciary Council to this new body that has been discussed. So my latest report to the Human Rights Council talks about the danger of reforms that start to politicize both judicial bodies and then also bodies such as bar associations that protect the independence of the profession of the lawyer. And I think here the popular election of judges really increases the risk that judicial candidates have to please voters in some way. They have to align with political parties, and we've already said what the ballot might look like. And those dynamics really pose significant risks to the impartiality piece of the requirement of an impartial and independent judiciary. That risk is especially credible given that the reform doesn't outline procedures for conduct of the campaign. And we've seen here, and I will use the US as an example, we see what happens in judicial campaigns. In some states, there are very problematic aspects that we could talk about in the Q&A perhaps. while the proposed reform does cite judicial election systems of 2 other states as examples and gives them as examples of promoting greater democracy, the human rights bodies of the UN have actually critiqued both of these. So the Human Rights Committee in particular has raised concerns regarding election of judges in the United States, saying that there are significant concerns. And then secondly, the special rapporteur of my mandate before me expressed concerns about the judicial election system in the other state, which was Bolivia. And I won't go into the concerns, but some of them I think apply here. So the proposed reforms to judicial terms, I want to also mention briefly. The idea that judges will be taken out of their current mandates, their mandates will simply end, and they will be replaced by these elected judges should really alarm us. International standards emphasize that judges have to be protected from arbitrary removal, and they have to have the requirement of this irremovability as a safeguard of their independence. And it's very obvious why, right? If they can be removed for political reasons, they're going to start to be worried about their own their decision making. So security of tenure is one of the key hallmarks of independence of the judiciary. And in short, what you see here is the removal of all sitting judges before the end of their term. And that is a plain violation of the security of tenure of judges. It's absolutely transparently a violation. And it also, and so it's both a violation of the rights of those individual judges, but more importantly for the whole system, it violates that inviolability that protects their independence and impartiality. It would dismiss this thousands of judges, and of course, as Laurence already mentioned, that's an incredible, it leaves the system bereft of people who have knowledge of a job that is not hard to take. It is not easy to take on a judicial job. It's a difficult job. It takes years to grow into. And I can't imagine new judges not having mentors who've been there for years. I mean, just imagine what that would be like. So that's a real concern. And then of course, the individual judges not having the right to retain their job, to retain their pensions, all of the other concerns that comes with. So I will close. There are other concerns to mention, of course, but I would like to just remind us that unlike elected officials, judges are not in office to represent the people in the way that elected officials are. Instead, they promise to be loyal to the Constitution and to the law. And that is their job. Their job is to uphold democracy by ensuring that the democracy abides by the rule of law. And that's a very particular democratic check. And it is a democratic function. It's just not a representative function in the way that elected officials are. And that is the way that I think we need to talk about. We're protecting democracy when we protect the independence and the impartiality of judges. And that is the way that we think about ensuring that that we can actually move forward in this discussion, that we actually are attempting to protect democracy and the rule of law as well. So I'll stop there and I look forward to the rest of the comments. Thank you.
Thank you. Thank you so much. That was incredibly clear and enlightening. I would hope the members of Congress and Senate in Mexico would have heard this. We're gonna make sure we're gonna send the recording. But thank you for that. It's my honor and privilege to introduce 2 federal judges, Mexican judges, who are here despite the very important efforts that are happening in Mexico right now. The judges, federal judges, and some states are on strike, trying to protect judicial independence and their rights as federal judges. So thank you very much for being here. We have 2 very brave women federal judges who have a very impressive career as judges, this judicial civil service that in Mexico, at least at the federal level, is an example for many countries in the region. Hopefully, we won't be talking about this in the past tense, but the Van Center is doing a lot of work in Latin America, 15 countries, as I mentioned before. every time a country asks for a good example of what a judicial civil service looks like, we give the Mexican federal judiciary. So thank you very much for being here. We're gonna hear first from Judge Montserrat Cid Cabello from the First Circuit. And just to explain that, I'm calling you judges because that's how we would translate to the US system. In Mexico, as in other civil law systems, we have the judges and then the appeal judges are magistrates. I know here is the other way around. So their title is magistradas, but they're appellate court judges. So thank you very much for being here. And I would like to ask you, because this is a reform, a change that would have impact not only in the abstract concept of judicial independence, but in the lives of a lot of federal and state judges who have studied and prepared and go to school for many, many years, subject to very rigorous evaluations, not only to enter the judicial civil service, but to stay there. So what is this reform gonna mean for the judges in Mexico, for the judicial system, and for the judicial independence? And if you can tell us a little bit about your current efforts, that would be great. Judge Maria Emilia Molina, you're also the president of the Women Judge Association in Mexico. So there's also a very important gender component being discussed in this reform because Mexico has done a lot of efforts to have parity in the judiciary, and that's a bit in danger right now. So if you can also tell us about that. Thank you so much for being here. So Judge Montserrat Cid Cabello will start.
Thank you. Good afternoon to everybody. First of all, I want to thank Band Center for International Justice, the New York City Bar, Fundación para la Justicia, La Justicia que Queremos, and Asociación Mexicana de Juzgadoras for this event. I feel honored to share this panel with Margaret Satterwhite, Lawrence Pantin, Ursula, that is not here, but she's
here.
yes, virtual, and my dear Emilia Molina, all women whom I admire. Thanks to Jaime for moderating the panel. It's really a privilege for me to be here talking about the judicial reform in Mexico, whose legislative process today had been voted in the House of Deputies and had set off the alarms in Mexico, not just in Mexico, but only international. What do we have in Mexico these days, particularly today? Indefinite strike in federal courts, and the recent vote of workers at the Supreme Court of Justice to join this strike, and also in local courts today. Protests of students against the reforms. Students are now in the streets in Mexico, all having common concerns about the approval of the reform that is not taking into account a real diagnosis of the justice system in Mexico and a serious dialogue in which no voice should be silenced and no judicial guarantee should be violated. In my opinion, the judicial reform is a regression on the human rights defense, professionalization, and judicial independence building. Judicial independence, it's not a privilege of judges. It's a social guarantee. People have the right to be judged with the certainty that there will be no undue interference in the solution of a case. And let me focus in what I think are the main concerns. Replacing all judges with popularly elected ones, as they say, and the creation of a judicial disciplinary tribunal to oversee judges. The initiative of the president argue as a main motive for the renovation of the judicial, the deep distance between society and the heads of jurisdictional bodies, judges, magistrates, and justices. The legitimacy of judges does not depend on the method of the appointment, but in the quality or their performance and decisions. In 2014, the first chamber of the Supreme Court recognizes that the judgment is the suitable mechanism for the social legitimacy and for an open delivery of justice with transparency. But also the judicial career or civil service legitimates the jurisdictional bodies in our country. The process of the election was one of the main concerns in the national dialogues organized by the Chamber of Deputies in Mexico. As a consequence, the reform draft presented by the Committee on Constitutional Affairs modified the bill submitted by the President, establishing graduality in the elections of judges and magistrates, the participation of judges and magistrates in functions, and the financing to implement the reform. Graduality in the elections of judges and magistrates, as Lauren said before, a first part of this election in 2025 and a second part in 2027. What are we going to have if it is finally approved by the Senate? It's that 2025 judges and magistrates, the election of 9 justices of the Supreme Court, magistrates of the 5 regional chambers of the Electoral Tribunal of the Judiciary of the Federation, the banshees of the Superior Chamber, all of the magistrates of the Disciplinary Tribunal, and half of the judicial bodies in each circuit and specialization will be elected. It is important to say that to choose the positions of judges and magistrates that will be selected, it will consider vacancy, quits, and retirements, and the rest will be selected by insacculation. The second part in 2027, it will be the election of magistrate of the Superior Chamber of the Electoral Tribunal and other half of judges and magistrates. The local judicial powers will be free to decide if the renewal is gradual or total, but the local elections must be in the same electoral periods. Even though this modification of the bill submitted by the President is a solution of the dismissal of all the judges and magistrates in just one moment, it does not attend the main problems associated with the process of electing judges. And let me explain you how is the process of selecting candidates and why I think that the person chosen will be suitable to perform the judicial function. In Mexico, since the judicial reform in 1994, the federal judicial power established a judicial career or civil service. And then almost 3 years ago, in 2021, with the reform with and for the federal judicial power, one of the main objectives was to reinforce a real judicial career for all categories to which a person can access by opposition contest. This judicial career law was published in 2021, and it established the judicial career and like an institutional system that regulates the entry, training, evaluation, promotion, permanence, and dismissal of judicial branch personnel who perform judicial tasks. This law established new rules consistent with a meritocratic and equal opportunity scheme so that people are chosen based on their knowledge, skills, and abilities. The procedure to fill the positions especially established exams and mandatory courses for entry and promotion in all different levels, not only judges and magistrates, but judicial clerks, court clerk, judicial officers, district judges. You know, it's for all the persons that work there. How we have been elected, competitive examinations, three phases with this examination: application of questionnaires, admissions of the best averages, and 2 evaluations, and the resolution of practical cases and oral examinations with a jury, and a solution of cases also, all organized by the Federal Judicial Training School. We have a school that it's the one that prepares for the examinations. The judicial career fosters a sense of identity and commitment to the role of the judicial branch to protect rights and impart justice in an effective and sensitive manner to people's circumstances. The judicial career provides jurisdictional warranties that allow judges and magistrates to be certain that the mechanisms for selection and promotion, evaluation, ratification, and performance are based on meritocratic criteria and not on arbitrary decisions, but also it gives us job security and immobility. So I think with the dismissal of the judges and magisters and the new electoral process, it will certainly throw back one of the most important achievements of the judicial reform on 2021 proposed by the president, which main objective was to consolidate the judicial career for a fairer society for this and future generations. I guess this is the main reason why students have raised their voice and are on the streets. I can understand how they feel studying law or other science, trying to have a fairer society, and suddenly they see how all the judicial system will be changed, risking the rule of law and the principles of democracy, such as independence of the judiciary. Even though the reform draft presented by the Committee on Constitutional Affairs modified the bill and incorporates mechanisms so that judges and magistrates in functions can be elected in the same position without the participating in the process of evaluation and selection of postulancy by the evaluation of committees and considering automatic pass to the electoral ballot. This certainly not solve the one of the most important problem on the popular election. It conditionates the job stability and compromises the impartiality of judges and magisters. I think these are like the main concerns, but I think the process of selecting candidates for re-election also compromises the impartiality because it's conditioning the job stability that we do have and can have a negative influence on the quality of the decisions, focusing the future constituents. The cost of the implementation, it's also a main concern, and in the draft presented, try to solve by using the funds and trust of the federal judicial power. That shall be extinguished as it was established in the organic law of the judicial power in 2023, but its effects are suspended. So I think this also is really problematic. The creation of the Judicial Disciplinary Tribunal, as Lorraine has said, the initiative proposes eliminating the Federal Judiciary Council that is now in the judiciary and placing the oversight and discipline of public servants of the federal judicial branch in this disciplinary court. It will depend on the executive and legislative branches, the way the members are going to be elected. So I think this will affect also the function. And as said before, the function shall consist of hearing, investigating, substantiating, and sanction of judicial officers for acts or omissions contrary to the law. What does that mean? That they are going to decide where an act or a omission will be contrary. I think this is also a main concern. It is a fact that the judicial reform will not improve access to justice and the public's perception of justice. It would have an adverse effect on what has been built in federal courts since human rights reform in 2011, and in all areas such as labor reform, energy reform, and different reforms that had been taken in Mexico. Although the reform was approved today in the Chamber of Deputies, now the senators have a valuable opportunity to go down in history as true defenders of our Constitution. I think now it's in their hands to ensure that neither democracy nor the separation of powers dies in Mexico. Thank you so much.
Thank you. And I think that your explanation of how you're to get to this point where you are now took you theoretical, practical examinations. And now they want to substitute this with letters of recommendation from your neighbors. But yeah, Judge María Emilia Molina.
Gracias. Buenas tardes a todas y a todos. Primero quiero disculparme por hablar en español. Mi inglés es muy malo, entonces prefiero decir las cosas desde como puedo explicarlas mejor. Y bueno, una disculpa a todos. Espero la próxima vez ya. Ok. Okay. Gracias por la invitación, gracias por estar aquí, por permitirnos a quienes somos parte de la Judicatura Federal de México exponer la preocupación que tenemos ante una reforma que se dice judicial, pero que supone muchos riesgos para la democracia de México y un ataque directo a los derechos humanos de las personas que habitan y que transitan por mi país.
So she apologizes for speaking Spanish, but she prefers to speak Spanish and tell and say more things. So she want to express the concern of this judicial reform that has a lot of risks for democracy, the rule of law, and for the life of people in Mexico.
Porque no es la afectación solamente a los ciudadanos de México, sino a cualquier persona que esté transitando por el país. Pero además supone una vulneración de los derechos laborales y de independencia judicial de todas las personas juzgadoras de México.
So the harm of this reform is not only to Mexican citizens, but also people in Mexico. Think about all the migrants that go through Mexico, and that there is harm to the rights, labor rights of a lot of employees of the judiciary.
Además, esta reforma tendrá un efecto importante en la región, dada la importancia histórica de México en Latinoamérica y, por supuesto, como socio en el TECMEC.
This is going to have an effect in the region, given the position of Mexico in Latin America and with other countries, including the relationship with the US because of the USMCA treaty.
Todo lo que se ha dicho respecto de la reforma pareciera que son ocurrencias de un grupo o del presidente que es como casual, pero yo quisiera poderles explicar que esta reforma responde a una estrategia planeada desde hace mucho tiempo y ejecutada con una gran precisión por lo menos los últimos 6 años.
It seems like this is a reform that occurs to the president casually, but it's really the response to a very well thought strategy that the president has been implementing the last 6 years.
Desde el principio del sexenio tuvimos varias amenazas de que se iban a presentar algunas iniciativas para modificar todo el Poder Judicial y las leyes que tienen que ver con ciertos mecanismos de protección de derechos humanos. Hace 6 años, casi, entró como presidente de la Suprema Corte el entonces ministro Saldívar y según lo que dijo el propio presidente de la República, el ministro Saldívar era el encargado de presionar a las personas juzgadoras cuando el presidente de la República le hacía una llamada para decirle que necesitaba que se arreglara algún caso y el ministro Saldívar lo que hacía era hablarnos a las personas juzgadoras y si no aceptábamos hacer lo que nos decía, teníamos presiones que tenían que ver con cuestiones incluso de seguridad para podernos quitar de los estados en donde estábamos y no siguiéramos conociendo de esos asuntos.
So the idea is that at the beginning of the president's term 6 years ago, he said that he was going to introduce some bills to reform the judiciary and other human rights mechanisms. And former Chief Justice Arturo Saldívar, according to President López Obrador, was the one in charge of pressuring judges to solve cases a certain way. And there were retaliatory actions if the judges were not doing what the Chief Justice was asking from them, including security issues and changing them to a different jurisdiction. Because in Mexico, like all federal judges can be moved to different jurisdictions, and the Chief Justice had the power to do that.
Una vez que termina su periodo, el ministro Saldívar y comienza la ministra Norma Piña, sube el tono de amenazas directas hacia personas juzgadoras y hacia la propia ministra presidenta. Hay uso de recursos estatales importantes porque en México el presidente tiene una sección diaria que se llama La Mañanera, que es desde Palacio Nacional, 3 horas diarias donde dice cualquier tema, sí, lo que quiere. Y hay una sección especial que se llama Cero Impunidad, donde aparecen nombres específicos de personas juzgadoras que no han hecho lo que el presidente quiere o lo que considera que es correcto, pero además pone el dato de la persona con el nombre, la persona juzgadora. En algunos casos se han filtrado incluso los domicilios personales y lo que dice es que son traidores a la patria o que hay un tema de corrupción específico para esos casos. Entonces, hay el uso de recursos estatales para señalamiento directo de las personas juzgadoras y además de descontextualizar la labor de quienes juzgamos, porque, bueno, finalmente no se da ninguna explicación de lo que es el propio juicio, sino que solo se descontextualiza un dato para poder atacar a las personas juzgadoras específicas.
So when former Chief Justice Arturo Saldívar ended his term, Justice Norma Piña becomes the new Chief Justice, and the attacks to the judges increase, particularly in the Mañanera, which is this daily morning press conference that lasts like 3 hours. And the president, that conference has a specific section called Zero Impunity, where he will say the names of people who are not doing what he wants, and he will disclose names, home addresses, and he will attribute these specific matters to corruption or basically treason. So there's a clear use of public funds without providing the real context to the cases, just saying that, or just attacking judges specifically.
Esto obviamente ha tenido un efecto intimidatorio contra las propias personas juzgadoras, contra nuestras familias, contra la propia institución. Y bueno, lo último que tuvimos fue en febrero de este año, la propuesta de reforma constitucional, la llamada reforma judicial, que incluye respecto de nosotros el cese de todas las personas juzgadoras, cambiándolos por personas juzgadoras de elección popular, el Tribunal de Disciplina y los jueces sin rostro, como ya se ha dicho, pero que además ha impactado, porque en la propia mañanera se ha mencionado, un absoluto desprecio a los sistemas internacionales de protección de derechos humanos. No solo porque no incluye ninguno de los estándares la propia reforma, sino porque ante comunicados como el de la relatora, a la que agradecemos todo su apoyo, pues se ha dicho desde la Presidencia de la República que no tienen por qué hacerle caso y que no tienen por qué meterse en algo que es de México. Bueno,
So the harassment to having to judges, their families, the judiciary in general. So in February, the president presented this bill, and there has been that would entail the dismissal of all the federal judges to replace them with elected judges and having these faceless courts. And then there's a clear from the President López Obrador dismissal of the international human rights mechanisms because there have been several reactions from the international community, including the letter that the special rapporteur, Professor Psarowoy, sent to the government. And the response of the president was that Mexico doesn't need to hear what other international mechanisms are doing because Mexico is a sovereign country.
En estos últimos días hubo 2 jueces de distrito, jueces federales, que dictaron dentro de un mecanismo de protección de derechos humanos que es el juicio de amparo en México, suspensiones contra el proceso legislativo, y la respuesta del grupo en el gobierno, de los propios legisladores de Morena, fue denuncia de juicio político, denuncias penales, denuncias de responsabilidad administrativa, y en redes sociales los propios legisladores señalaron y amedrentaron con linchamiento social, diciendo que tenían la mayoría del pueblo para poder hacer lo que quisieran respecto de la seguridad de las propias personas juzgadoras que dictaron estas resoluciones judiciales.
So lately, two federal judges issued court orders suspending the legislative process, and the response from the government was threats, impeachments, criminal complaints, harassment from the members of Congress and Senate, arguing that they have the majority of popularity of people in Mexico.
Desde el 19 de agosto, los trabajadores del Poder Judicial de la Federación y a partir del 21 de agosto también las personas juzgadoras estamos en suspensión de labores atendiendo solamente los casos urgentes como resistencia a esta reforma.
Since August 19, the employees of the federal judiciary, and then on the 21st, judges joined a strike, but they're still hearing urgent cases.
En este momento ya fue votado por la mitad del Congreso de la Unión, falta la Cámara de Senadores. Está en riesgo cualquier avance que hayamos tenido en México respecto de protección de derechos humanos, obviamente la independencia judicial, pero principalmente la protección de los grupos más vulnerables, aquellos grupos que por supuesto no votan, de niñas, niños, adolescentes o personas migrantes, que es respecto de quienes concedemos la mayor parte de las protecciones de derechos humanos.
So the Congress approved the reform. Now it's pending before the Senate, but there's a huge risk that human rights protections coming from the judiciary, especially for vulnerable people, women, children, and migrants, will be unprotected.
Además está en riesgo lo poco que habíamos avanzado en temas de paridad de género. Según lo que establece la reforma, 466 mujeres juzgadoras seremos cesadas, mismas que hemos llegado a través de concursos de oposición donde hemos roto muchos obstáculos, hemos superado muchos obstáculos para poder lograr estos puestos de decisión en un sistema como el de todo el mundo, absolutamente machista y patriarcal, donde en México hace apenas 70 años somos consideradas ciudadanas y actualmente tenemos aproximadamente el 30% de lugares en la Judicatura Federal como juezas o magistradas y como parte del feminismo de esta iniciativa seremos todas cesadas, aun cuando aparentemente hay formas para que en la elección puedan incorporarse mujeres, pero a quienes ya llegamos no se nos respetaría todo el trabajo que hemos hecho para la paridad.
Gender parity is also at risk because there are 466 women judges that would be dismissed as part of this reform. Women judges who have faced huge obstacles in a system that's already run by men, and that only 30% of judges in the magistrates in the judiciary are women. So part of the feminist fight would be reverted, even when supposedly there are mechanisms to include women judges in the election. The current women judges would be dismissed.
En México no tenemos un sistema de verificación de calidad de las personas abogadas. No hay un estándar para tener un mínimo de conocimientos o de capacitación para quienes podemos ser abogados o abogadas. Lo que sí tenemos es una carrera judicial hasta este momento sólida, donde quienes formamos parte del Poder Judicial Federal tenemos una capacitación constante y tiene esta carrera judicial 30 años de evolución con una Escuela Federal de Formación Judicial que tiene 46 años de experiencia, donde pasamos exámenes para todas las categorías, tenemos capacitación constante, se ha buscado la paridad de género en todas las categorías y donde las personas juzgadoras hoy tenemos un promedio de 15 años de experiencia en carrera judicial, no 15 años de juzgadora, sino 15 años de toda la carrera judicial, porque no podemos llegar si no tenemos antes esta carrera judicial. Hoy, el día de hoy se propuso que incluso para ser los nuevos jueces no sea necesario ni siquiera ser abogado, que fuera cualquier persona las personas que somos ahora juzgadoras, además, después de los primeros 6 años somos ratificadas, eso quiere decir que somos inamovibles, es decir, solamente podemos perder el cargo o podíamos perder el cargo si no tuviéramos, si tuviéramos un procedimiento de responsabilidad por una causa grave. Pero bueno, lo que se pretende ahora es tener jueces por 9 años que pudieran ser reelectos, y eso implicaría también una curva de aprendizaje en perjuicio de todas las personas muy grave. Perdón.
So in Mexico, there is no mandatory bar association, meaning that the ethics mechanisms of lawyers are not existent. So the judicial civil service is the members of the judicial civil service are the only ones who have real continuing learning education ethics obligations, and they have a school that has been there with for 40 years of experience forming these judges with looking for gender parity in all the categories. In average, judges and magistrates have 15 years of belonging to the civil service because they all begin as part of the civil service. And it was proposed today that the judges, part of the requirements, they don't need to be lawyers. As long as they have a college degree, that's enough. Now what happens is that judges, after 6 years of service, they have a fixed appointment. It's not lifetime, but it's limited, it's just fixed, and they can be dismissed only for serious reasons. Now they want to appoint judges for 9 years, and that would also be losing a lot of the experience because there would be a learning curve.
Y ya con eso termino. Gracias. Lo que están atacando en este momento no solamente es nuestra decisión de vida, en donde está invertida toda nuestra realidad prácticamente desde que estábamos en la universidad, nuestras familias, etcétera, sino que realmente lo que están atacando es la posibilidad de que México pueda seguir teniendo una democracia sólida, o por lo menos estar construyéndola, un acceso a la justicia para todas las personas, y que haya una forma de justicia mejorable. Se piensa destruir lo poco que sirve, no para mejorarlo, sino para controlarlo. Y en este momento, el partido oficial le falta un voto en el Senado para que no pase para que puedan tener la mayoría que se requiere constitucionalmente. Hay 43 senadores de oposición en este momento que tienen en sus manos la defensa de la democracia de nuestro país. Muchas gracias.
So this last part is that this reform is attacking the life decision of a lot of people and the possibility of Mexico to have a solid democracy and access to justice. That's perfectible. And what works is going to be destroyed, not to improve, but to control. The political party in power needs one vote in the Senate to pass the reform. So currently there are 43 opposition senators that will have the future of Mexico in their hands. Thank you, thank you, thank you very much for that. And now we're gonna go to Ursula. Are you there? Can you hear us?
Yes, I'm here.
Thank you. Ursula is a program director at the Due Process of Law Foundation. Ursula has been running the Judicial Independence Program for a few years now. You started when you were extremely young, and you've seen a lot of these attacks to the judiciary and reforms in other countries in Latin America. So unfortunately, Mexico is not alone in the issue of threats to judicial independence, reforming the judiciary, trying to control judges. So what could you tell us about what's happened in the region, what has been done, and what could Mexico
Oh my gosh.
lost you for a moment, Ursula, but we are back.
I'm here. Can you hear me?
Yes, we can hear you.
Okay. Can I go ahead?
Yes, yes, please.
Okay, well, thank you very much, and thank you for your patience. I know that it has been, and we are maybe very short of time, so I will be very brief. I want to thank you, Jaime, and thanks to the Van Center for the opportunity of being here, sharing the panel with these powerful and inspiring women that I admire, especially the UN Special Rapporteur Satterwhite. So I would like to share some ideas on other judicial reforms in the region, because not necessarily reforming the justice systems is a bad idea, but we're talking about here on the lessons that other experiences can give us for the Mexico case. So I'm talking here about very profound reforms that imply constitutional amendments and reforms to the institutional design of the justice systems, or the modification of key processes, such as the mechanisms to appoint high-level justice system judges or high prosecutors, and are reforms that alter the layout of the weights and counterweights among state powers, and in some cases they introduce safeguards to guarantee the independence of the judiciary and the Attorney General's office. So I thought about two kinds of reforms. So I'm here presenting two groups. The first group could be maybe Bolivia and Ecuador, that are similar, because both of them amended their constitution in 2008 in Ecuador and in 2009 in Bolivia. In the case of Bolivia, the new constitution was subject to a referendum that was approved massively, and the reforms were promoted by a charismatic political leader, President Evo Morales, and they introduced a modification on the election mechanism to all the high courts by popular vote. But it also transformed the status of the acting judges, all the acting judges, onto temporary judges. And the idea here was to create a justice system that could accompany the principle of a new form of state, a state that was plurinational, that was indigenous peasant, and that gave us, the indigenous people, a new special role, empowering them into decision-making spaces. In the case of Ecuador, the reform was also pushed by President Correa, and the amendment of the constitution was more broad, but they created a fourth power, not only legislative, executive, and judicial. They also created the popular power that was represented by a Council of Citizen Participation and Social Control. And this new body, made up of citizens, had a key role on the appointment of a lot of high-level authorities, control and oversight bodies. And in this reform in Ecuador, the Constitutional Tribunal was replaced by a constitutional court, and the same happened with a lot of bodies that made up the justice system. So in this first group, we have the following features. The reforms were pushed and promoted by a strong political leader, the head of the executive. They were both approved by referendum. So it's not a reform that was only approved by the legislative. The citizen voted and approved these reforms. The reforms of the justice systems were part of a paradigm or of a more broad paradigm shift on the structure of the state. And the reforms responded to the necessity to advance a political project that needed new rules. Unfortunately, in these cases, in Ecuador and Bolivia, these reforms led to paradigmatic court cases at the Inter-American Court of Human Rights for violations of the principles of judicial independence. We have the paradigmatic cases of massive removal of high courts in Ecuador that are three cases, three sentences. In the case of Bolivia, despite the massive removal of judges with more than 90% at some point of provisionality, there have not been yet rulings from the court, but they will come at certain point. And the second group are made up by two cases, El Salvador and Colombia, that I chose. And in these cases, the reforms of the Constitution were part of recommendations or negotiations of peace accords. In the case of the Salvador, the Constitution of 1983 was amended in 1992 as a result of the peace accords after more than 30 years of internal armed conflict. And the reform introduced safeguards to secure the independence of the Supreme Court. They introduced the judicial career. They introduced a rule that only judicial reforms were valid if they were promoted by the Supreme Court. They cannot be imposed by other powers. So in general, they amended, they created the Council of the Judiciary, and they amended the selection process of Supreme Court justices so that any Congress could vote and elect more than 1/3 of the Supreme Court to ensure that not any political composition of the legislative could take over the Supreme Court. And in the case of Colombia, well, they decided to create a new jurisdiction, the jurisdiction for peace, with new organs, new tribunals, and a body that had the role of a prosecutor to investigate cases that were related to the internal armed conflict. And what are the lessons of this second group? Well, the reforms were result of a negotiation, and this is very important. The role of international community to accompany the reforms was key. So are there lessons for Mexico? I think, yes, we can get lessons from both groups. And I had identified three. The first would be that the more actors involved, the more discussion and oversight from national groups and international actors, the better. The second lesson would be maybe the answer of this question, if political projects could be a good reason to reform the Constitution and to change the configuration of, or to reform key processes of the justice system. In my opinion, yes, but while we are talking only about democratic projects in which the power recognize that the human rights and the freedoms are boundaries to any policy or the same political projects. That's maybe the reason why the reforms that follow situations of armed conflict were those who finally had this primary goal and were the ones who had the more success, in my opinion. And the third lesson could be that these reforms that ended up being regressive or anti-democratic were those that weakened the more broad body of judges, and that didn't include them or involve them in the debate. So to finalize, I would say that any reform to the justice system should include and hear the voices of the judges. We have two representative here, two women judges, federal judges, and for what we have seen, not only them, other groups of organized judges, associations, and even the voices of the Supreme Court justices haven't been heard by the political actors in Mexico. So if they are the ones that have, not only because they are affected in their rights, their secure of tenure, that is of course very important, but that because they know that the impact on the status of these judges would impact at the end the access to justice of thousands of citizens. So I would end up there, and well, thank you very much.
Thank you, Ursula. I hope you were able to hear the applause. That was very interesting. And it's great to have these cases from other countries in the region as a reference of what can happen next. So we're gonna open it for the Q&A. So we're gonna take a round of questions and then a round of responses. And that should be it. We have a few minutes, so please be brief with your questions, not comments. And please introduce yourselves. Yes.
Hi, Doug Bassel, I think it's called. Professor Satterthwaite referred to the indirect value for democracy of the judiciary as a check. But I heard the reference to I think it's the Tribunal Federal de Elección. That sounds like a rather direct threat to democracy, and I wonder if someone could comment on that. Because if the elections are being judged by people who've been handpicked by political parties, what kind of elections that? Welcome to the United States.
Thank you, Doug. There's one question in the back. Yes. Thank you. Yes.
Hi, my name is Pablo Medina. Well, it's very interesting news, but I mean, the decision is already, we can further as into new products if we want to. Because it has been decided by the So the thing is that I'm really interested in what's going to happen before, because this is going to lead us to the work of the institutional practice. This is going to bring, this is going to bring the issue before the Mexican courts and eventually to the Supreme Court. And the Supreme Court will have to decide if all these legislative process is good. Where there have been a lot of violations in the legislative process. So the Supreme Court will have to decide if that's right or not. We're going to need a constitutional practice in the judicial power.
Thank you.
Hi, my question is more about the gender parity issue. I'm wondering what has been done to make sure that
Thank you. Anyone else? Yes, I know. Thank you. Anyone else? No, yes.
Is there any way? There any way to present counter reform, counter proposal from point, start focusing on?
Thank you. And I saw one more hand. Was there? Yes. in the back.
Hello, my name is Abdul, I'm 19, I'm on that unit. My question was, you mentioned elections, and I was going to ask, is there the US also at times, guilty of having political appointments, especially in the Supreme Court, as we saw recently? So why do we judge Mexico more than we would judge the US?
Okay. Thank you. And I would add a question from a discussion I had with Andy. And I would like to direct this question to you because I know that you are an administrative judge. You oversee cases of antitrust. And this is related to Yesenia's point. Some companies in Mexico are saying that nothing is going to happen because they are going to agree on arbitration on every matter. But the truth is that you can't send to arbitration everything. So I would like to hear from you. But I think that's it for questions. So we can do a round of final remarks answering the questions. So we can start with Lawrence.
And I'm sorry, I was not texting, just I was trying to send Ursula the questions because she cannot hear them. I just want to, to let you know I'm not a rude person who, just starts texting. But actually it didn't work. So because I don't have Wi-Fi. But anyway, so you're going to have to repeat them. No. Okay. The first question about the electoral tribunal, actually, it's not a problem only in the future. It's a problem right now, because as we mentioned, not all judges are currently designated on the basis of merits. And some of them have a political appointment. And actually, electoral judges have an a political appointment. There were, and right now we have the situation we have, the reason why Morena has so many seats in Congress is because there's a very complex technicality in the Constitution that could have been interpreted differently, and that could have led to less seats to Morena, because it depends if you consider a party or a coalition. I don't want to enter into many details. It's very complex, but the thing is, the actual election tribunal decided to go on with the interpretation that is more favorable to Morena, because they are very close to Morena, and because in the reform, suddenly they made a change, and they gave the opportunity to current judges, electoral judges, to apply again to be re-elected. No, I am just saying, so it's not just a futuristic, possibility. It's happening. It happened right now, actually. So we are.
It works, yes.
Yeah, but it can. Yeah, actually, that's true.
I'm really sure.
I'm so sorry. I'm so sorry, Doug. I was trying to get all the questions. There's one more that I just want to address, which is what can be done if the business community can do something. And another question that was about nothing had been done and it's too late. I will put them all together, but I think it's gonna, I'm afraid it's gonna pass, but I think we still have an opportunity to do something in the secondary legislation to avoid the worst. It's not, we won't have many, a big margin to do something, but something might be done to avoid the worst situation, or to be even worse because every day they, imagine something worse. So we can try to avoid that at least. And the other thing is, I think one thing that can actually make a difference is international influence and pressure and international business pressure. And the reason I'm saying that's not, the current president doesn't care at all, but the president-elect Claudia Sheinbaum has, I think, a very different view on those things. And she has her hands tied right now. She will take office on October 1st. And I think that's when we need to have a lot of pressure on her because she might have, I'm sure she has a different take on on her own international reputation. And I'm gonna leave it there. Sorry to be so.
María Emilia.
I think to answer the question you have, I think there's a concern. The U.S. Chamber of Commerce has made a call to Mexico, like they are focused on the reform, not only the judicial reform, but also another reform that wants to eliminate all the autonomous constitutional bodies. So I think there are like all the alarms are put on Mexico because for investments, I think there are two principal concerns. You have for one side the judicial reform and for the other the elimination of the autonomous constitutional bodies. And let me tell you something, the elimination of the autonomous constitutional bodies will affect, as it was said today, the independent body that puts attention on all the regulatory system in Mexico. I'm thinking about antitrust, I'm thinking about telecommunications, special energy is another one, special sectors in Mexico. And I think they are really concerned about this elimination because it's a matter of like security for them to invest in Mexico. And I think the government has the alarm also set in how is affecting all the investments and how peso has been depreciated according to these procedures. And by the other side, the judicial reform also will affect, I think, all the disputes they have now at courts. Why? Because I think it will be a regression. The constitutional bodies, the Supreme Court of Justice, have resolved different cases of antitrust and telecommunications and energy. So I think if investors have that, like the security that we are judges that have a judicial career and are well prepared, and it's been years of preparation, I think it's gonna be more dangerous if you eliminate these autonomous bodies and if you also change all and remove all the judges and magistrates and justices, because that will mean that the rules are gonna be changed. So if they don't have any security to have like a certain to invest, I think maybe they are taking in consideration what are they going to do in the next few days. And I think this will be a main concern to the new president elected in Mexico for the next years. Like to see the financial effect these reforms will have.
Thank you, thank you.
Solo agregaría, se pretende hacer la reforma al Poder Judicial porque es el único que constitucionalmente puede revisar cualquier otra reforma. Si el Poder Judicial está controlado y no hay nadie que pueda revisar la constitucionalidad o el respeto de derechos humanos en cualquier otro acto que se decida respecto de cualquier otra reforma, todo lo que se haga, con independencia de si está respetando o no un estándar constitucional o convencional para temas de cualquier materia, sería posible sostenerlo jurídicamente porque no habría ningún juez que pudiera decir alto. Lo que se pretende con esta reforma es controlar todos los jueces, tanto de los estados, de los 32 estados del país, que son los de primera instancia, los de apelación de cada uno de los estados y los federales, que tenemos esta como doble función, que es de cuestiones federales como cuestiones de delincuencia organizada, narcotráfico y por supuesto los temas de energía, competencia económica, etcétera, pero también quienes estamos encargados de la revisión constitucional de derechos humanos y de la protección de derechos humanos. Entonces, a todas las personas juzgadoras serían más de 7,000 personas juzgadoras cesadas y sustituidas en este sistema, que por supuesto, al no existir nadie más que pudiera revisar, entonces la destrucción de los organismos autónomos para transparencia, para control de energía, etcétera, y la Guardia Nacional, que estaría militarizándose prácticamente todo en México, y cualquier otra reforma, pues no tendría ningún filtro ni ninguna forma de detenerse.
Perfect.
¿Lo repito?
No. So she only wants to add that the reason for the reform to the judiciary is that it is the only body that can review any other legal reform, its constitutionality, or any other government act. Everything done, regardless if it's violating the constitution or law, will be decided by judges controlled by the government. And this is for the federation and the states, remembering that federal judges have this dual role in which they decide federal matters, but also review human rights protection for the whole country. And so the destructions of these autonomous bodies, militarization with the National Guard, would have no remedy before a partial judiciary. Thank you.
Thank you.
Ursula?
Just a brief comment on what can be still done. I think Justice Ginsburg would have said, persist, resist and persist. I don't think that necessarily because the reform at the constitutional level is approved, we have to kick the board. I think we still have opportunities to damage control at the developing law level, and also keep pushing for a counter reform. Mexico's constitution is the most easy to amend of all the region, with more than 400 amendments. So it sounds a major shift to reform the constitution, but it's so as it is easy to reform, it is easy to counter reform if we design a strategy and follow it. And also I would say keep going to the international human rights bodies to denounce the violation of judicial independence. I have in mind right now one example in the case of Bolivia. As I said, the constitution changed the status of acting judges into temporary ones of all the judges. So judges who have been, like, for example, 10 years in their positions and remained in them for 20 more years, with 30 years of career, they try to be removed only by opening a new contest, a new selection process for the same position that they were occupying for 30 years. And as the international law does not ban or prohibit temporary judges or provisionality, that it's not a desired thing, but it's not banned. So they couldn't say anything because they didn't activate any actions. I think the international human rights body would have to give another interpretation to the consent. And so if it were me, I would, as a judge, try to remain in the system, even if it takes to participate in the new selection processes, but not consenting on the or like saving the position that this process is the consent on this process or the consent to participate in these processes does not mean to consent on the violation of the judicial independence, of the safeguards of their own judicial independence, and keep trying to pursue that violation to be established by international human rights bodies. So we have like the political strategy, the counter reform, and the advocate for better safeguards at the secondary laws, and at the same time try to have a position as judicial associations, a strong position, try to find partnerships and to look for the solidarity of all the other judicial associations in the region at the sub-regional, regional, or even global level. I think that you, and here I'm talking to the Mexican judges, you are not alone. I think that civil society, we are with you, and also other judges from all the region and the globe.
Thank you, Ursula. We're gonna close with a special rapporteur.
Okay. I actually was going to say something very similar to what Ursula just said at the end, which is not to answer all the technical questions which have already been asked, but to say that I do think this is going to be a long process no matter what. And so I think the kind of sustained attention that we need is represented here in this room. And I feel hopeful because of that. But I do hope that that means we will all stay in this. And I think in particular to commit to the judges to say that we will continue to insist that human rights and international law norms apply. And I do think also that lawyers, many of whom are in this room, need to be organizing within bar associations. I think insofar as judges can speak out, and I think they can, especially when democracy is being attacked, that's really important. And we've seen that, and I'll just give the positive example of Poland, where there were judges who very much were attacked by the political powers that used every single resource they could. But the judges really did organize and stand up. And I think that now we can see they are starting to reclaim their rule of law and starting to put back in place a constitutional order that's so badly needed. So just to say thank you all for being here. And I think that we all need to stay in this, and thank you for this evening.
No, thank you so much. Thank you. Thank you all for being here. I have nothing left to say. And this is the New York City Bar Association. You're always welcome. This is House of the Lawyers of the State of New York.
Pero esperemos que lo demos para algo. Gracias.